Well, thank you so much, and good morning, everyone. And we do have a number of important topics to cover here today. And thankfully, we do have two great experts who we'll be introducing here coming up in just a moment. Just a few housekeeping details before we get started. The slide presentation and a recording of the webinar will be sent to all participants. Many of you have submitted questions when you registered, so we'll try to address as many of those as we can today. And if you have a question now, as we mentioned, you could send those to us in the chats. We'll handle as many questions as we can after the PowerPoint presentation. As the partnership has been doing for so many years, we will have an update on legal and legislative developments, both on the national and state level. We all know adult use of marijuana is now legal in New Jersey, and there are now close to 80 dispensaries selling the product throughout the state, with more to come. This is an ongoing challenge for New Jersey employers, and we want to help them as much as possible to deal with that situation. And we also want to cover the new possibilities regarding use of oral fluids for drug testing. So let's bring on our expert speakers for today. Nancy M. DeLogue, well known to members of our drug-free workplace program, has presented for the partnership for a number of years. Nancy is a shareholder of Littler Mendelsohn PC, and is a nationally recognized authority on federal and state drug-free workplace and drug testing issues, and has spent much of her career focusing on workplace drug policies and procedures, including programs that are mandated by the Department of Transportation. Also with us today is Lauren Marcus. Lauren is also a shareholder at Littler Mendelsohn and works out of the Newark office. She represents and advises employers in various aspects of employment law, and regularly advises and counsels clients on a wide array of day-to-day concerns, including leave of absence issues, wage and hour questions, and handbooks and policies. We are grateful to have both Nancy and Lauren with us, and I'll now turn things over to them.
Well, thank you, Bert. Let's try and manipulate my slides and talk at the same time. Thank you for such the kind introduction. Lauren and I are really happy to be here. We're kind of honored to be invited to speak and to connect with those of you who are on the call today. As Bert mentioned, we work with employers and we counsel employers on drug-free workplace issues. Sometimes we are, we're brought in on a particular situation or something like that, but we don't have the opportunity necessarily to hear what's bothering you before it happens, right? To have the dialogue, the discussion, to see the questions, frankly, to hone our own counseling abilities by hearing from a broader group of employers about what's going on in their workplaces. So hopefully we can respond to some of that and learn that. Hopefully also we will be able to answer your questions and hear from you about what's keeping you up at night. We also should be able to share a few completely de-identified stories about the types of questions we're seeing. And if nothing else, Lauren, we can help them feel less alone, perhaps, with some of the crazy situations. So this agenda is just kind of what we're going to cover today, but it is not something that we're going to follow, section by section, but just what you can expect to learn today, sort of an overview of evolving drug use law. We are, of course, going to talk about marijuana a lot because that is the most common drug of abuse, while also, like alcohol being legal in New Jersey right now. And given the conflict with federal law, that's still causing a lot of employers fits. But we also wanted to help you, on dealing with a workforce that is using drugs. We know they are, whether it's lawful or unlawful. Sometimes they're impaired, sometimes they're not, but the issues keep coming up. So we're going to cover that and, of course, talk about not your policy specifically, but giving you some ideas and some takeaways and tips that we've had before. So my colleague Lauren is, of course, in the office in Newark, and she gets to see more than I do in some ways. And so I'm going to try and make sure that she's able to weigh in quite a lot. She's getting over a little bit of a cold, so if she's hoarse or you don't understand, just go ahead and put that in the chat. But starting with the overview of what's going on in New Jersey, we just want to quickly remind you, right, about the cannabis law that was in 2021. It's really prohibits, it permits the broad use of cannabis, and we are talking about marijuana. And why do I do that? It's kind of like my ground rules for every time I talk about the cannabis law. Not all cannabis contains THC. THC is the psychoactive ingredient in marijuana and the thing that gets people impaired. And so typically that's what we're worried about in the workplace, right? The fact that someone might come to work impaired or under the influence, and make bad decisions. Now, there is an increasing amount of I'd call safety scholarship or medical scholarship that's suggesting that people will use a marijuana product and they'll get high and they'll feel high for about 4 to 6 hours, and then they won't feel or be high any longer. But their decision making and their reaction time may be slowed for 24 hours or more. We're not going to talk about that today because we're not scientists, and frankly, although it is a concern of yours, there's not much we can do about it, right? As long as marijuana is lawful. But we can focus on impairment, and we're going to talk about that. So when we talk about marijuana today, just be clear, I'm not talking about any kind of cannabis product that does not have more than trace amounts of tetrahydrocannabinol in them. And that means we're talking about marijuana that is unlawful at the federal level, right? But lawful here in New Jersey. So what does the law say about marijuana in the workplace? Lauren, you want to take that one on?
Yeah, that's the big one, right? So New Jersey, took things pretty far when they passed this law. So employers cannot make employment decisions, meaning you can't refuse to hire someone, you can't fire someone, you can't take any adverse action against someone because they do or do not use marijuana. So that's really the big thing here. Not only is marijuana legal in New Jersey, but it's a protected status. So if someone uses marijuana off duty, you can't take any adverse action against that. That's the thing that's keeping employers up at night. That's the thing that's leading to all the questions about what are we doing with drug testing. This one sentence on your screen. This is, really the big issue that everyone's dealing with.
Lauren, do you still see a lot of confusion about that? Do employers still call and say, I'm not quite sure about the scope of what I can and cannot do?
Constantly. We're also seeing a lot of employers who are not proactively changing their policies. So they're calling us when they have the positive test. So it's, oh, this person just tested positive for marijuana. What do I do? Can I really not fire them? It seems as though it's something that people are just, a lot of employers are still being very reactive to this law. We're starting, I think, this past year to see a lot more companies kind of being like, I guess this is in it for the long haul. I think a lot of companies and employers, we all kind of thought maybe, as we'll discuss later, that guidance would be coming out, that something would maybe clarify this. People were kind of waiting. And I think now we've reached the point of, we all got to get on board and figure out how to comply with this law.
That's interesting. Yeah, I'm still seeing questions, but like you, even if I'm talking to an employer that's not, based in New Jersey, more of them seem to be aware of these changes. And you mentioned the drug, you get a call when there's a drug test. I put the next slide up that there's actually a pull quote from the legislation that is it's something I want to focus on. It's an employee shall not be subject to adverse action solely due to the presence of cannabinoid metabolites in the employee's bodily fluid from engaging in conduct permitted by the legislature. It's interesting, right? I think in the past, when I've either presented with this group or talked about this, I've focused on, what does it mean solely due to the presence, right, of cannabinoid metabolites in the body fluid? And one of the things we're going to talk about today is some of the develops in another direction, which is, well, what about the presence of cannabinoids in the employee's bodily fluid? They're not metabolites. Does that make a difference under this statute? Again, this is just a little bit of the overview. And I know, Lauren, you and I talked about this when it came out. The statute actually does not prohibit drug testing, right?
Right.
It lists all these types of testing that an employer might do, including random testing. which is interesting in and of itself in New Jersey. But it doesn't necessarily allow you to do anything with the results because you need more. And how do you show impairment at work? I think we've talked, and many of the people here will be familiar with the concept of like an impairment recognition expert. I'm going to see if I can pull this slide before we get into the slides. That the impairment recognition expert is not a thing right now in New Jersey, right? Just a level set there.
Nope, it's still not here. The law said that we were getting guidelines. We were going to have these workplace impairment recognition experts, the wire. The law is all full of talking about the wire. We still do not have a wire. It's for those of you, who, are in New Jersey like me, this is pretty normal for New Jersey. Unfortunately, we're pretty big on getting laws, and the guidance or regulations seem to take a while to come through. But as of now, we still don't actually have a wire. So we're left to do the best we can to comply otherwise.
And as I recall, they did publish something that said like, do the best you can and tell otherwise, right? So it's not like you're, going off without any authority there. And this law applies to almost everyone in New Jersey, but not everyone, right? Like there's a couple situations where there'd be like a federal preemption.
Exactly. There's federal preemption if you are party to a contract and you would lose the contract or have an adverse, problem with the contract by complying with this law, then you don't have to. And obviously, we're seeing a lot of questions about what about DOT drivers. The DOT is going to preempt this law.
Yeah.
Presumably. So
yeah, that would be a direct federal conflict there, but it's only for the people who are subject to the DOT testing, right? So like you could say like, oh, people who have a commercial driver's license and drive for us are subject to this testing, but people who maybe are the dispatchers but don't have any ability to get behind the wheel of a bus would not be. Which brings me to a question I still get a lot from people all over the country about New Jersey, which is what are the carve outs in the statutes for safety sensitive jobs? I mean, we can certainly turn away or preclude people from working in a safety sensitive role in New Jersey if they use cannabis, can't I?
nope, no carve outs. New Jersey just does not have the exceptions. I know that everyone's up in arms about this. We are a state with a huge construction industry, and there is not a carve out for it. It's been something that I think keeps a lot of people up at night, to be honest. We get a lot of calls about people being concerned about safety sensitive employees. I think, a lot of people are really increasing their training for reasonable suspicion, really trying to keep a closer eye on people at work, but there's no carve out for them.
Yeah,
the only carve out in the law is for these federal contracts. Sorry.
One of our participants suggested we random drug test politicians, and I'll just say that's been tried. The U.S. Supreme Court struck that down as performative, so that probably won't work either. Interesting how that works, right? Okay, so hang on, let me move the slide forward. Bill at Drugs Don't Work New Jersey has asked me specifically to make sure we talk today about edibles, because I think Bert mentioned at the lead-in, you said there's like 80 different dispensaries and growing across the state. We are now increasingly seeing like food products and things like that. And so one thing I'm doing, and this is probably more for the end, but marijuana, we prohibit the use of marijuana at work, the possession of you. We also prohibit the possession and use of marijuana products at work, which will include your edibles. I wanted to give you like an overview of like where we're going here and like where, how does New Jersey fit in with the rest of the nation, right? Because we do get these questions. These jurisdictions on this have limits on marijuana testing, right? And so you'll see New Jersey there, Rhode Island, New York. Those were the only three, I think, the last time I did this. And then I've added a couple new ones: Maine, Washington, Nevada, and California. And I gave them this little blue glow because these restrictions on marijuana testing apply only to pre-hire testing. And so a few more jurisdictions beyond New York and New Jersey have added some protections for off-work use of marijuana, but it is not exclusively for for employees. It's mostly applicants. And I think I misspoke just now. It's Maine, Nevada, and Washington. California, though, just passed a law that does offer protections for the off-work use of marijuana. And I don't know if you've experienced this in any of your businesses or if you're all, kind of focused in New Jersey, but in having been with Littler, which started out as a California-based firm for more than 20 years now, I can tell you that what starts in California often then rolls eastward. So this will be a little bit interesting. What California has said now, it is unlawful to discriminate against an applicant or employee who is engaged in the lawful use of marijuana outside of work. And Washington, whoops, I went too fast. They just have a pre-hire testing. Unless the job is safety sensitive, you can't do pre-hire testing in marijuana, or you're doing a test that measures active THC in the individual system, right? So for certain jobs, they can decide whether to use a test that measures active THC, or they can, decide to forego pre-hire testing, altogether for the non-safety sensitive roles. And of course, not everyone tests everyone pre-hire anyway. California, it's a little broader, but there are carve-outs, right? And this is what like Lauren and I were talking about, who's covered by these laws. I just want to put up, I think we had this before. Some other jurisdictions have off-work marijuana use not a reason for discipline, unless you have a policy prohibiting it. Okay, Connecticut's kind of like that too. And all these carve-outs for safety sensitive roles. So in the jurisdictions where marijuana is not prohibited, it is not necessarily protected to the extent New Jersey does now. Now, somebody said to me, active THC does not indicate impairment. And I am willing to acknowledge that is true, but it's a little bit like alcohol, right? What do we do with alcohol testing right now? It's lawful in all 50 states to do alcohol tests, particularly when you think that there is impairment. And we don't measure impairment. We measure a level of blood alcohol level, right? The amount of alcohol as a percentage with blood. So what sort of the next best thing, I think, where the science is going to be in terms of employer testing, as opposed to, your doctor doing some sort of significant blood draw and making decisions, is to look into whether if someone has active THC in their system, can they equate that to likely impairment or possible impairment? Some jurisdictions will allow you to act on that basis if there's other indications of impairment, and others will just say that that's enough. And that's kind of where we're going with California. So spoiler alert, right? Oh, Lauren and I have talked a lot about California's new law. It was actually passed 2 years ago, but only became effective this January. And so a little bit like New Jersey, we're still seeing employers get up to speed on it. I don't know if you've had any calls about this recently, Lauren, but I certainly see them in our firm's email looking for advice. And what it does is it actually amended their Fair Employment and Housing Act, which is like the law against discrimination here in New Jersey, and makes it unlawful to discriminate against an applicant or employee just because they engaged in the lawful use of marijuana outside of work. Notice this: employees in the building and construction trades are not protected. I don't know who their lobbyist is, but in California, this new limit on marijuana testing, both pre-hire and during employment, does not apply to anybody in those trades. There are also the typical carve-outs that Lauren mentioned before for federal contracts and things like that, places where you're required to test. What's interesting about this, and the reason I wanted to bring it to your attention, and Drugs Don't Work New Jersey wanted you to be familiar with it, is what the law does permit, right? So we've already told you it's unlawful to discriminate, right, against somebody who engages in the lawful use of a marijuana or cannabis product away from work, off the job and away from the workplace, and is unlawful to act on the basis of an employer-required drug test that has found non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. And that's significant because urine tests, which are probably the most common still, tests for non-psychoactive cannabis metabolites in the urine. If you think about it, it makes sense. You go to the doctor, what's being excreted from your body, they're measuring what's going on inside you or has gone inside you, but it's already passed. It's certainly evidence that you've used a drug or drugs recently, but not that it's not precise about what's actively circulating in your system, right? So guess what? What kind of test can apply with the new California law? Oral fluid testing. As it turns out, and I am not, again, a marketing person for the oral fluids industry, but most, if not all, of the oral fluid drug tests measure active THC in the individual's oral fluid, which is like the saliva and other. Apparently, it's not all saliva in your cheek and mouth cavity, and so employers in California, other than those in the building and construction trades industry, are now using this, right, as a way to measure use that is recent enough that it is active in the individual system and may cause a problem. You'll note it's also, unlike New Jersey, we don't need to also show impairment. We just need to show that the oral fluids tests were approved. So, Lauren, we talked last year about how the US Department of Transportation and the federal government have adopted oral fluids standards, right? Do you get questions about in New Jersey whether there's any regulations or rules about oral fluid testing very commonly? And if so, do you point them in the direction of the federal workplace standards?
We do, and exactly. We try to use it as a guideline, which I think makes sense. A lot of people ask, as you mentioned before, like, with alcohol testing, there's standard levels that have become, acceptable as measurements. So we get a lot of questions asking, is there a level of, test results if you're using oral fluid testing that's acknowledged to be impairment? In New Jersey, there's not yet. It'd be nice if that comes down the pike. Does California, have they adopted anything like that yet?
No, it doesn't seem to. It doesn't. It just has to measure active THC in the oral fluid or blood sample. By the way, we haven't covered this, but I don't recommend anyone do blood draws. I don't know if that's just saying. It's a medical exam to do a blood draw. It complicates things. That is in a way that's sort of legally, in my opinion, unnecessary if you can avoid it. But that's yeah, we get asked a lot about oral fluid right now, and my understanding is that in order to kind of get past sort of the marketing and the FDA doesn't certify them for medical purposes, but they have to demonstrate that they reach certain cutoff levels. I think that's where people are looking, but California doesn't have a cutoff level specific in that statute. I will say though, it may not be so particularly relevant because you're looking for active THC in someone's blood, right? And I've read 2 scientific studies that seem to say what's in your oral fluids maps at about a 1-to-1 ratio to what would be in your blood, but it's in and out of your system in less than 24 hours. And most of the medical review officers that I speak with say it's in and out of your system in like less than 12 hours. And so you're really, if you're going to test this way, you're only going to catch people who engaged in very recent use, such that 1, it's active in your system, and 2, it's not going to build up and cause a positive test days later, which is, I think, the concern most people cite with urine drug testing.
Agreed.
So there's some potential benefits to oral fluid testing, and if you haven't thought about doing them, it's something that people like. The shorter detection window aids you in showing present impairment. I know we have some people on the call who vehemently disagree, but it's a lot better, right, than a urine test that measures past use for sure. It's always an observed collection, unlike urine testing. And yeah, oral fluid collection is totally legal in New Jersey right now. We've actually seen a lot more organizations shift toward the oral fluid test because of these laws giving some protection for off-work marijuana use. But prior to 2019, prior to the pandemic, I was aware of a lot of really larger companies adopting this, typically in retail or manufacturing settings where someone might be either apparently impaired, but they're not really sure, or following an accident, because a lot, but not all, of the oral fluid tests are not just collections, but they do like a quick screen. And if it's negative, the person would be sent right back to work. And if it was positive, the person would go for a more thorough test that would be performed by a laboratory. So it allowed them to kind of use whatever their testing policy was and put someone back to work quickly if they had a negative test result. So those are some things to think about. We obviously recommend training, and I just put this in here. If you do an oral fluid test and you get an instant result, or if you do a urine test and you get an instant result, as attorneys, Lauren and I are very much against that. If you acting on that, we're fine with you using them, but we don't want that to be the end of your inquiry, right? Because any drug, with the exception of PCP, that you like, unless you do a drug test, you get like a presumptive positive result. Maybe it says marijuana, maybe it says benzodiazepines, maybe it says cocaine. There is a way that could have gotten into the person's specimen lawfully. And I mean federally lawfully, not even New Jersey law cannabis lawfully. So once that comes back presumptive positive, the test, we believe, should go to a full laboratory, be confirmed, and then that test result should be vetted with a medical review officer. I know that's in all of your New Jersey drug don't work packets. Why do you have a medical review officer? So that you're not flagging people who are using drugs lawfully. You're only focused on the illegal use of a drug. So confirmatory testing, yes, we don't, I know it's great. You can get a quick screening test with oral fluid. You can with urine too, but most of my clients don't want to do their own urine collections. But this is something that just keep in mind. We're not endorsing that you move forward with final employment action without that. So this is the section you were referring to, Lauren, before. How does this sort of testing, and how does the New Jersey marijuana statute, CREMA, handle the wire and the determining when there's someone is impairing? This is the language, right? The physical evaluation be conducted by an individual with the necessary certification. I think the next slide here. Oh, yes. And then your drug test must be scientifically reliable. So I think that might have answered the question we just got about, are there cutoff levels, right? You have to be able to say it's scientifically reliable. And I'd suggest that you go to your vendor and ask them about that. But the marijuana, you still in New Jersey, you can't just act on the positive test, even if it's oral fluid, right?
Right, you have to do the physical evaluation. So even though we don't have a wire yet, the commission that was created by the law did come out with, maybe last year or the year before, like a sample reasonable suspicion checklist, basically, that they recommend you use. And it's pretty standard to what we've always been using anyway. It's got the checkoffs, and you should have 2 people observe someone and note your observations of why you think someone's under the influence or impaired at work. So you would note all of that and do the test, and that combined would be enough for you to take action. So that's critical, and that's one of the reasons we, have been suggesting in New Jersey the oral, fluids test, because since it is active THC and since it does have a shorter window, if you have this conduct or behavior that makes you think someone's impaired and that's documented, and then you do the test and it comes back positive, that's going to be stronger support for you taking action against someone.
That makes perfect sense. Yeah, that's good advice. So we have a question, which is, can we comment on New Jersey law or experiencing for continuing patient cannabis use when admitting to a hospital for an acute illness? Thank you. And I would say, as an employment lawyer, I don't know that I can be fully responsive here, but what I can tell you generally, right, is that healthcare providers that are subject to federal regulation, so for example, a hospital where they accept Medicaid and Medicare, are not only subject to DEA or Drug Enforcement Administration regulations on whether the people who have access to the medications can be using cannabis. They also have to worry about ensuring that whatever treatment they provide right, is good treatment. And so I think some of them are perhaps concerned about the liability for allowing the illegal use from their perspective, right, as a federal contractor or grantee of cannabis on site. But there's also a huge issue, right, with cannabis is a strong, whether you call it a medication or a drug or it is likely to interact with other medications they might prescribe. So my thought there is no, I cannot comment on it other than to say, I hope that any hospital is going to be worried about its own liability and obligations, but any physician is also going to be concerned about whether the use of cannabis is appropriate while other things are going on. We actually have some slides about some new drugs coming up that are being seen as drugs of abuse, and one of them called kratom they're seeing overdoses they had a whole rash of them down in Florida, and they were related to either benzodiazepine, which is like your Xanax, or your cannabis already in your system. And if you had those already in your system, then the risk of overdose apparently went up. So sorry, that's a long answer to say no, I can't really comment. But I did want to say, there's a lot going on here besides just what happens in the workplace. And that is something to be aware of, that there's things to be concerned about beyond just that.
It does also just bring up a good point to reiterate, is that New Jersey, when they passed this law, when we had this legalization of recreational marijuana, we didn't get rid of our medical marijuana law. So that is still protected, and there are still requirements. So like if someone tests positive for marijuana, you had 5 days to send over a letter saying, oh, you tested positive, do you have a medical marijuana card? Even though you don't need a medical marijuana card anymore to use marijuana legally in New Jersey, those requirements technically haven't been repealed or replaced. So when you're doing any of this, you should still also remember that there may be a requirement to speak to someone or engage in the interactive process. It does not mean they can use it at work. So you're still fine if you think someone's impaired at work, but it's just kind of an added layer to always keep in the back of your mind for analysis purposes, because we're still seeing people bringing those claims, still relying on medical marijuana use, and it's kind of been forgotten from some employers' minds. So
that is a really great point, and one that I think that we keep seeing people who don't realize their off work use may be protected, but they're asking for permission to use it at work. And I would say thus far, I've never seen, not in New Jersey or in any other state, a court say that it would be a reasonable accommodation to allow the use or possession at work, but that could change, I suppose, right?
We recently had someone asking for that. The supervisor said, no, you can't use marijuana at work. And their request was for an accommodation to be transferred to a different supervisor. We were like, no, it's not the supervisor's problem. You cannot use that at work. Like, that's still not okay.
Yeah,
but,
that's a good thing. Another supervisor can worry about this for us.
Yeah.
We already covered the part about the workplace impairment recognition expert, so I'll move forward. So a couple of people in the comments have said, well, oral fluids testing and testing for impairment this is not the same thing, or active THC in your system is not the same thing as impairment. This is what the California legislature said. As science has improved, employers now have access to multiple types of tests that do not rely on the presence of non-psychoactive cannabis metabolites. Okay. The alternative tests include impairment tests, which measure an individual employee against their own baseline performance, as well as tests that identify the presence of THC in an individual's bodily fluids. So Lauren and I are lawyers, but we're not giving you legal advice because it's like, we don't know any of your businesses. We haven't got that attorney-client relationship with what, but I will tell you that this makes us super uncomfortable in California. And and I'll tell you why. I'm sure that impairment tests are something that's, scientifically being worked on, and to try to determine how you can tell whether someone is not just under the influence of THC, but also impaired by it. But the thing is, none of these tests are either widely available or what we would call validated. and what is validated. So if it's a test, and you can see this slide here, that measures dexterity, your dexterity a couple of days ago was really good, but your dexterity today is not good. And so we conclude that you may be impaired and we send you home, looks to me like a problem under the Americans with Disabilities Act, right? There are lots of people whose dexterity is either not good or which will fluctuate, and that may be caused by a disability or medication taken in association with a disability. So I know there's this press, I keep hearing like, well, when are we going to know when people are impaired? I want to kind of like just say, we're not big fans of that right now, because we're the defense attorneys would have to defend, the imposition of a test that maybe wasn't validated, to say that, no, this test shows not just impairment or reduced capacity, but reduced capacity that is related to the ingestion of a substance other than a different issue that had to be accommodated. So I think we have some of the types of testing that we're seeing out there: retinal scans, marijuana breathalyzers, perhaps more. I talked to an MRO, a medical review officer from Higher Right, Lauren, Dr. Todd Simo, and he did mention marijuana breathalyzers. He said they're keeping an eye on them, but he said that as far as he was aware, they were like $110 per test right now. So they're not going to be probably financially viable for employers if they're even available in anyone's neighborhood yet. So, and the other thing I already mentioned, is it a medical exam? Because we don't want to do medical exams if we can avoid it. Right now, drug tests are not medical exams under the Americans with Disabilities Act, so you can conduct them in accordance with state law, but without worrying about whether someone is immediately going to pose a direct threat. But that wouldn't necessarily be the case for some of these other types of tests, and medical exams are generally limited under our both federal and state laws right now when you can conduct them. So that is everything we have for oral fluid testing. Lauren, I'm delightedly tossing you gun rights and marijuana. What is going on with the use and possession of firearms in New Jersey?
So New Jersey, I mean, every time that anyone's like, wait, but what about construction? What about an exemption for this? And we say there's no exemptions. And everyone's like, oh, but what about an exemption for this? We say, my example is always, we are allowing police officers in Jersey City to walk around with loaded weapons after testing positive for marijuana. We are taking this law very seriously. There are no exceptions. So some police officers in Jersey City were suspended and terminated for testing positive for marijuana. And the city was forced to reinstate them, basically saying that they were allowed to lawfully use marijuana off duty. And so there's been an ongoing legal battle about whether federal law preempts that. There are laws about who can carry firearms. You're not allowed to, use drugs and have convictions and all these other rules. And there's a fight over whether federal law preempts it. We all thought federal law preempted the state law, but the state took the position of, no, the federal government's going to have to come down here and intervene and actually tell us that. We're not taking that position voluntarily. So there's currently a lawsuit pending in the District of New Jersey, where Jersey City is saying, nope, we want to be able to fire police officers. And the police officers in the city recently, a few days ago, filed a motion to dismiss. So this is an ongoing legal battle. We'll have to see how it pans out, but it's certainly interesting. It's kind of the only reason when we talk about DOT, I say, obviously DOT preempts this law, and in the back of my mind, I'm like, unless someone decides it doesn't and decides to fight it. I mean, I didn't think we'd have this battle either, but that's kind of where we are. So,
I mean, I don't know how many of you have weapons, but it is something to be aware of if you are also, a cannabis or a marijuana user in New Jersey. I have that middle bullet point on the slide is something I added. Some of you may have seen on national news that about a year ago, there was, I think it was the beginning of the school year, a 6-year-old in Virginia brought a gun to school and shot his teacher kind of through the hand. And there was a lot of different allegations, but the question was, how did a 6-year-old get the gun? And his mother was charged with two things. One was child endangerment, and the other was getting a firearm and putting on the firearm permit that she did not use marijuana when in fact she did. So she was sentenced to 21 months in prison on federal charges after the prosecutors learned that she had marijuana and a firearm. Now, that had nothing to do with the child endangerment. She got another 24 months from that in a separate court proceeding at the state level. So that's a real, like, as lawyers, that's the kind of thing that, gets headed up to the courts of appeal, like, and even the Supreme Court sometimes, like, we've got people in Virginia, marijuana possession and use is recreationally lawful in Virginia also, right? So which is it, right? Are you committing a federal crime if you have a firearm and use marijuana, or aren't you? I mean, at some level, if the state of New Jersey says, sure, we'll let the cops use marijuana, the federal government may have something else to say about that. So we will see. Crazy. Gives you an idea of all of the different issues that get dealt with and balanced every day. We did want to talk about a few other things with opioid abuse and some of the other drugs that I mentioned that are coming up. And we'll also make sure to try and take some questions. But there's still over 100,000 deaths in the US each year from opioid overdoses. 80% of them, I think, are it's 80% of all overdoses. And what's interesting to me is the National Safety Council, which kind of focuses on workplaces, said that and took the occupational safety and health data and said more than 525 people died of opioid overdoses at work last year. And that is not something I have usually seen in the last 20 years. We have more and more employers are adding Narcan or naloxone to their safety kits, and because they want to have it available, kind of like they've got Band-Aids and Advil. Narcan used to be prescription medication, but it's now available over the counter without prescription. And the federal government had made a deal with the manufacturer, so it's much more affordable. If you haven't taken a look at it, you might want to do that. And then I put this little quote here. At NewJersey.gov has posted, right? Like most jurisdictions, New Jersey has a law that protects people who supply Narcan against, criminal or civil actions for trying to provide help. The good news is that Narcan does nothing if you're not having an overdose with opioids. It's just what they call an agonist. So you're not going to make anybody worse. It's just that if that's not what's going on, it's not going to help either. But people who provide naloxone to people who they suspect are having overdoses should be immune from prosecution, and the victim not go well or be upset that they were given naloxone. So it's something to look into. There's a lot of programs. OSHA has encouraged them. Our colleagues in California, sort of separately from the other law we just talked about, are doing a lot of Narcan at work policies through Cal OSHA. So it's something that might be useful. I bring it up because I did have a client call me in the last year. It was in New Jersey. Lauren was out that day, and they're like, "Listen, we had a guy overdose after work. He not after work, at work. It was after lunch, and he had said something to them that maybe he touched something during lunch that would have caused it. But the long story short, he was operating yellow iron, and he slumped at the controls." And they called 911, and what they told me was that they are usually pretty far from immediate EMT support, but luckily they were in the area and they came in, they administered Narcan, and the guy was revived. And this story has a happy ending. The story almost had a different ending though, which was that after he tested positive, after he was recovered, they sent him for a drug test, and they called me and they said, well, he tested negative. And I said, well, I mean, do you know that he overdosed? And they said, yeah. They said it was fentanyl. And I said, does your drug test for fentanyl? And they were like, let us check. Oh no, most standard employer drug tests do not test for fentanyl. So I said, well, I think if he overdosed at work and you want to take some kind of adverse action, I can't recall now if he was in a union or what they were going to do. and I think you can act. And they said, well, we've never acted without a positive test before. And so I'm just going to stop talking and let Lauren talk about all the things you can do without a positive test, because we get these questions all the time.
I have to tell you, my new favorite thing in New Jersey is to do things without positive tests. I feel like if, they're making it harder for us to rely on tests, right? You can only take action based on someone actually being impaired at work. So if you have actual concrete proof that someone is impaired at work, take action. Same goes for people being in violation of your policies and being in possession of drugs at work, being in possession of any of that. If you have a policy saying you can't be, you can take action for that. You don't have to actually test someone. I had a client call me. They literally walked into a woman's restroom and found someone smoking marijuana. You don't have to test that. They are in front of you smoking marijuana. You can fire them. That's not allowed at work. So, I think that in the past we've been really reliant on the testing, but now if they're saying, oh, the testing might not be okay because it's lawful and it might just show that someone lawfully used it last week, then why even bother doing the testing if you have concrete proof that someone is using or impaired at work at the moment? That's kind of that's my quick spiel on that. I know we're running low on time, so I'm just kind of.
Yeah, no, it goes on and right. I think that we get all those questions about what's available. And, I think that it's unfortunate, right? When test and discipline is sort of the, the reaction. A drug-free workplace program is a whole thing with employee assistance, education, ideally ahead of time, so they know what's expected and what they can and cannot do at work. Most of the employers I do work with would prefer not to discipline people, but they need to know, right, what they, they say, well, if we don't let them go, can we hold them to certain standards, or they, are they disabled at that point or something? And there is usually a way to do it. We might have to document it. So those are the kinds of questions we get. We want to kind of make sure that drug testing is neither the beginning nor the end of your drug-free workplace program. So let's see, let me go up here. As you mentioned, some resources, right? Some of you are asking, NIOSH, then this is the investigation arm of the research arm of OSHA, United States Department of Labor, has a whole page on opioids in the workplace, and links there that can talk about this. And one of them I clicked on and put up here is, what is a recovery ready workplace? That is a program that was originally, I think, the name anyway, not to say other people weren't doing it, but it started up in New Hampshire, where they actually put together a toolkit of things to help your workplace be welcoming to people who may have developed over addictions, particularly with opioids, but not necessarily. It can be alcohol, can be other things, and resources to help be a supportive workplace in that regard. And this is all available to you online if you're interested in taking those steps and looking at those resources. Also just wanted to mention a few psychedelics and emergent drugs of abuse. We got the magic mushrooms are now legal in 3 states. People are talking about them as maybe used for medicine, but there's nothing that would protect such use at work, right? If you saw somebody with those at work, you could still say that's a problem. I mentioned the kratom. That was just something where about 24 people in the Florida area have died from what is currently non-regulated. In Florida, a lot of people use it for pain management and to actually, if they are, perhaps they've abused opioids in the past, but apparently it can be dangerous, especially if used in some high concentrations, the type that we're seeing, even with cannabis, where you take pot grown in the backyard is a really different product than a vape cartridge with 95% cannabis, or an edible that has a high dosage. There's also, and this was just recently, something called gas station heroin. But weirdly, although this is still really kind of cutting edge, the tianepatine, if I'm even pronouncing that, it's something that they use for cardiovascular issues in Europe, but it's being sold over the counter here. And a lot of people have been poisoned with it in New Jersey specifically. So if you haven't heard of that, just go out and Google it. The DEA, the Drug Enforcement Administration, just published a couple of days ago that a lot of the poisonings in New Jersey, apparently that stuff that you got at the gas station also included some synthetic marijuana. So, you know, buyer beware, these are unregulated products. Maybe if you do want to use something like cannabis, you could go to a regulated dispensary and not the gas station. I mean, I'm not a doctor, but just be aware that these are some things that are coming out. I've had this picture for the last few years, and people ask me if that's a real thing, and like, yes, those are things that were obviously seized, right? Because why do you think they were seized? Not because they contain THC, but because of the trademark infringement. But there's all kinds of products out there that are now being infused with THC, and as you look to update your policy and procedures, and you say no marijuana at work, that's real, no drugs at work. This isn't, a lot of employees aren't going to think of these as drugs, right? These are edibles. And can we eat them at lunch? Can we have them at break? It is okay, right, to say no, not during the workday, even as a matter of New Jersey law. Lauren, what's the rule for people over 21? Do you have a lot of clients that have people under 21 working there?
I actually don't, this hasn't really come up. So I mean, if you're under 21, it's not lawful to use marijuana. So theoretically, you're not protected because you're only protecting someone's lawful use. I will say I haven't had many clients try to distinguish between the two, but it's not a bad idea. We got some questions,
alcohol, right?
Exactly. We had some questions in the comments about school. If you think students are high, same thing. It's not lawful if you're under 21. It's like alcohol. So you would do what you normally do if you think someone's, drinking at work or drinking at school, I guess.
Yeah, I think that's right. It's still okay to discipline workers who come to work impaired, even without a positive test. We covered that.
Yes.
Okay to drug test in New Jersey. It's really more limited, like what you can do with the result if you don't do the test right. But I don't sometimes get employers, again, I'm out of state, right? So they'll be like, oh my gosh, we're a New Mexico-based employer and we drug tested one of our workers in New Jersey and it came back positive for marijuana. What do we do? And sometimes the answer is nothing. Like, or not exactly, like we walk them through that, but we have to figure out, how to document that, whether, if it was a protected use, how to ensure that there's no blowback. I also get this a lot with respect to New Jersey law. Does it, like, let's say I live in New Jersey and I have a job in Pennsylvania. Can I use cannabis, or can the people in Pennsylvania discipline me? And I think the answer is no, like probably not, but it is something I'd want to run down. Do you have that medical marijuana card? And sometimes people say, well, I'm a federal contractor, or we have a federal requirement. And someone just wrote to me last night and said, employee in New Jersey works in Pennsylvania. They say it's a federal requirement that they test. But why they said it was a federal requirement did not make sense to me. I was like, there is no such federal requirement. So please be sure to really drill down before you decide that you're fit into one of the exemptions, and maybe assure yourselves of that before.
That's probably the number one question or incorrect assumption I get from employers is like, we do federal work, so therefore we're required to test, or we're subject to the Drug-Free Workplace Act, so like we're required to test. Everyone should just be aware that doesn't require testing. It requires you to have a policy saying drugs will not be in the workplace, but it doesn't require testing. And if it doesn't actually require testing, like the DOT requires testing, then you likely are not exempt from the marijuana law. Oh, my camera just fell down. Sorry about that. And you're likely still not allowed to take action based solely on the positive drug test.
Oh, that is, yeah, I think that's interesting that that's just your most common question, because I do get it, but that makes sense. We tried to answer most of the questions that came up in the chat to the extent they were employment related, right? Because that's what we're qualified to speak about. But we saved a few minutes at the end. If you have questions, please go ahead and type them into the chat right now, and we have some time to address them. If your question is not really an employment situation or something that we didn't cover, then, you know, we'll answer it if we can, but even though we're not giving you legal advice, it's informed advice. If it's something about, you know, what happens somewhere else, then my opinion is probably no better than anyone else's on that topic.
There was one question that was sent through Cindy through the chat. I wasn't sure if you had addressed that one or not. It was about high school related. Can you speak on how high schools in our state should handle students that are expected of being under the influence during school hours? Is there anything you can comment on that?
Well, I feel like, Lauren, you kind of addressed the idea that, you know, it wouldn't be lawful use. And so, you know, how to address it, I think would probably go within the bounds of everything else that a high school would do with respect to discipline or intervention. But I don't know, is there anything to add specifically? I don't know that we're, I don't know.
I don't think so. I think it would be the same as someone you think is drinking, you know, at school or something.
So we have a question, somebody who operates car and limos, but they're not subject to a CDL, and not sure what they can require. I mean, certainly no marijuana in or around the vehicle. Some things may depend on, frankly, the number of passengers you can carry in a particular vehicle. If the vehicle is large enough to require any kind of US Department of Transportation medical exam as a qualifier, then the use of marijuana would be medically disqualifying. But if it's just a car service, my suspicion is that you're probably limited in New Jersey. What would your quick thought on that be, Lauren?
I agree. There's nothing you can do. You know, New Jersey has its version of the DOT regulations, you know, exactly. There's certain passenger vehicles, certain size vehicles that require other medical cards. If anything falls into that, you can, you know, try to use that. But if it's just, you know, car drivers, there's probably not much you can do about it.
Yeah, you'd be looking for impairment. You'd be looking to communicate what the concerns are. I mean, certainly the insurance would be an issue, right? So your insurance company can maybe help you ensure that the drivers know what's expected and then follow through if you need to. So I think that brings us to the end. Bert, is there any other questions that we may have missed?
Yeah, that's correct. And you both did a marvelous job, obviously, with another terrific, thorough and very comprehensive presentation, and also kind of addressing the questions on the fly too, as they were being asked, was very helpful too. So
we
as
wanted to give you a rest.
we are beginning to bring things to an end here. So just a moment, if we could, from both of you, just to offer some final thoughts on the subjects that were covered today. And Lauren, why don't you go first for the final comments?
Just my final comment is, you know, we'll keep an eye on what's going on with the that gun litigation in New Jersey is really interesting. But my general advice to employers is to, you know, be proactive, try to have policies in place prohibiting, you know, marijuana in the workplace. Make sure, I think Bill sent a message that they're going to send out the reasonable suspicion checklist that the state made available. Make sure you have that. Make sure you use that. That helps
And
with reasonable suspicion. Yes, and the slides, make sure, you know, you train people to know what to keep an eye out for reasonable suspicion so that you can, you know, properly test and take action against people for impairment at work. I think that's really the key to complying with this law, but keeping a safe workplace.
Terrific, Lauren. Thank you very much. And Nancy, you have the final word.
Oh, thank you so much, Bert. Just really, for me, it's communication. We keep seeing employees who say it's legal now. I can use in the parking lot. I can use on my way to work. I can have it in my pocketbook when I visit you and my clients or customers. And the answer to that is usually no from the employer's perspective. But these employees are not, you know, out to misbehave. They just need clearer communication. And if we're confused, right, all the questions we have, you can be sure your workforce is too. So for policies and procedures, my best advice is to kind of have these dialogues with people or publish things that help them understand what you expect.
Terrific. Well, thank you once again to our speakers today. And we know these are challenging times for employers when it comes to handling marijuana in the workplace and these other issues. But I think your presentation provides employers here in New Jersey with a very good sense of where things are and what steps they can take to maintain a healthy, safe, and drug-free workplace. The Partnership for a Drug-Free New Jersey will continue to monitor any new developments on these issues and we'll continue to provide members, keep them fully up to date. A recording of the webinar from today and the slide presentation will be sent to all of you who have registered. If you would like to receive a certificate of participation, please respond to the email when you receive the slide presentations. And once again, thanks to all of you who attended the program. And on behalf of the Partnership for Drug-Free New Jersey, we wish you the best as we move forward on this most challenging of issues, and we wish everyone a good day.